suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
It is time to talk law with our in-house, very own talkback lawyer, David Whiting. It's your chance to get that free legal advice. Give me a call, 1300 222 774, the number 1300 222 774, or your law questions for David Whiting shortly. Good morning, David, and Happy New Year.
Happy New Year, Richard.
Now, you may have had 2 weeks off.
Yes.
But we set you some homework for your break. Did you manage to do your homework?
I did.
Between your...
Well, could I say I did it this morning? Would that be fair?
That's how homework should be done, right?
Indeed. Just before you pack up and go to school.
Yeah, exactly.
We had 2 calls. Sue from Surrey Hills lived in a 3-unit development. The unit next to her had put in an air conditioning unit and mounted it on the wall. And what's happening is presumably there's effective reverberation between the neighbour's wall and her wall. So whereas if it was out in the open, it might be a fairly quiet air conditioning unit, it's a very noisy air conditioning unit. So I wanted to look at the model rules in the Owners Corporation Act to see what her options were. There is a rule that I think it's 5.3 of the model rules that says you're not supposed to do anything that interferes with the use of the common property. But none of that helps Sue. Where she's stuck with is the law in relation to nuisance, and that would involve an application to the Magistrates Court. Now, having said that, there's a provision in Section 160 of the Owners Corporation Act that says if a person is aggrieved as a consequence of the operation of the Owners Corporation, you can make a request for assistance to the Director of Consumer Affairs, and they will appoint someone to mediate or conciliate the dispute. So there's an option. She might also like to talk to some acoustic engineers and work out whether there is something that could be done, some kind of acoustic baffle to stop the noise is where I would be looking rather than spending lots on lawyers. And the other one was Lewis. Lewis lived close. Sue was in Swan Hill. Lewis was in Surrey Hills. He had what amounted to a residential tenancy problem, but upon reflection, his tenant wasn't the person living there. He had entered into an agreement to lease the house to the government, and the government provided supported accommodation to person in that property. So instead of looking at the Residential Tenancies Act, it's a question of Lewis looking at his lease agreement with the department and find out if there is a default in that would enable him to take action. So it's not a residential tenancy because the tenant isn't an individual.
So, yeah, it's not he's got to find out who
he's got to go and read his contract as opposed to his rights as a landowner under the Residential Tenancy Act, which he also said he wasn't the slightest bit interested in giving effect to because he was apprehensive about what the resident might do.
It is that time of the week, Tuesdays after 10, where we talk to David Whiting, all things about law. If you've got a question for David, give us a call, 1300 222 774. That number, 1300 222 774. David, did you spend your holidays, taking your mind off the law, or did you immerse yourself in it?
Richard, I probably like you, I tend to read all the time. So yes, I read some cases while I was away, and I subscribe to a number of newspapers. So that's what keeps me busy. We're minding our daughter's dog, so that's kept us close to home. So had a few day trips, no overnighters.
Great. Now, first up, we've got Dorothy is in Colac. Good morning, Dorothy. What's your question for David?
Hello. Thank you for taking the call. My husband and I have been working with a Nepalese couple who've put forward an application to the Federal Court. They've now received their bridging visa A. On the document called Notice of Filing and Hearing, sent to the Nepalese friend with a seal of Federal Court, page 5 states they have to fill in a service of application. It's reading from it. The application must be served on each respondent within 5 days by delivering it to the Department of Home Affairs at the address below. The document they've received did not have the address given, A couple of questions. What happens if
So they're
the
making an application to the federal court.
they have already
So
made
they've filed the application. The
Yes, they
application's
have.
been accepted by the court and then
Yes,
given
it
back
has.
to your friends and said,
Yes.
now serve it to the people below.
Yes. Well,
Right.
it hasn't got any list of whom to serve to.
Yes.
And it also has a space for the address will be inserted by the registry, and there's no address.
Well,
there.
I would give you two different alternative approaches. One would be to ring the registry and say there's a defect in the document that's been issued. Would you mind completing and resending? Or I would jump in the car and drive to Melbourne and lodge it with the department here.
Can the document be done online?
What do you mean? Do you mean the application or the service of the application?
Service of it. Can it be?
The general practice, you need to look at what the federal court rules are, but the general proposition is that you can only effect service by email where the person you're serving has agreed to receive service by email.
Okay.
So, for example,
yes.
if I was acting for the department and I'm not, probably never will, would be my view. You would get a notification of an email address from the department. So the answer would be that you should talk to federal court registry, and get them to complete and resubmit to you the document. That, I think, would be the preferred way. If you can't get an answer fast enough, you might deliver the document to the department in Melbourne.
Thank you. And if this is not done, what is the result if they don't put in their service of application?
It may be that your application lapses. No?
Okay. Yes, thank you.
Okay.
Thanks, Dorothy. Sarah is in the Yarra Valley. Good morning, Sarah.
Hi. I've got a property that was purchased last year in the Yarra Valley, and we've got unreasonable flow of water coming from our neighbour's property.
What
into
renders
our
it
shed.
unreasonable, Sarah?
It's excessive water that's flowing to the back of our shed. That
No.
means that we can't drive in.
Yes. The trick is it's a question of causation.
Sorry, it comes off their driveway, so they've surfaced their driveway.
Okay. If they've surfaced the driveway and are not allowing for what I'll call the flow of the water, well, first of all, there's no absorption anymore, if there was absorption before. And secondly, it might be now moving in a different direction. Yes, you have the right to take your neighbour to VCAT. There is a limitation period, but it's probably 6 years. But it would be 6 years from the time they well, so no, it's my view is it's probably an ongoing obligation pretty much every time it rains.
Yeah, that's what I was wondering, because on VCAT it does say on their website 6 years to the date for the time limit, but
Right,
we've only
so-
just moved here in the last year.
Right, okay.
So does that apply to
well,
us?
I would be talking to a town planner or surveyor. There's an application you can look at called Nearmap, nearmap.com, and you can buy aerial photographs. There's a subscription that will allow you to go back maybe 10, 15 years to see when it went in. So and that will give you some idea of how old the driveway is. That may have some impact.
And does it matter when the driveway was surfaced with concrete?
Well, the problems that you've got, based on what you've said, Sarah, is that if this has been going on for 20 years, the natural flow of water is probably where it is now.
Yep.
So it's what I'm trying to help you get is some indication as to when the driveway was paved or treated in such a way that the flow moved to your property.
Okay.
All right.
All right. Thank you.
Thank you, Sarah.
Dilip is in Atwood. Good morning, Dilip. What's your question for David?
Good morning, David. A question is, I want to give some money to my daughter, like example, up to $250,000 or $200,000 to
A
buy
very
a house.
generous father. Yep.
To buy a house when she get married.
Yes.
And is there a way something happened to the marriage down the track that she can have that money? Is there a document we can sign oh, I don't want it, but at least stays with her.
Now, if she dies, do you want the money back?
No, not dies. I'm talking.
No. The difficulty is if you give the money to your daughter and you can make it a loan. So if you give it, then it's hers. It's clearly hers. It will be treated as a gift at the time. So from the point of view of it being her asset, I have no issue. If you want to make sure that you get it back if something goes wrong with the marriage, then
I don't want, at least to stay with her, not going to the other party.
No, well, I'm sort of... The problem is when the marriage comes to an end, there's going to be a division of assets.
Yeah.
And while the $250,000 will be treated as your daughter's asset, it's a financial resource that she's got that her partner might not have. Yeah. If I was looking for as close as you could get to a gilt-edged position, is that I would lend them both the money.
Okay.
With a formal loan agreement that sets out when it's due to be repaid, and say that in the loan agreement, and then in your will, give her the loan, give her the benefits of the loan. So where I get, every now and then someone will say, well, look, the marriage wasn't very long and my daughter has died, I'd like my money back. Well, a bit hard. Because if you've given it to her and they buy the property as joint tenants, her interest in the property disappears, you have nowhere to go.
Yeah, okay. So give as a loan.
So it's a loan to both of them. It's secured against the house in some form, perhaps supported by a caveat, perhaps not. And you, in your will, you say, I've lent $250,000 to my daughter and her partner, and I now give the benefit of that loan to my daughter. Okay.
Thanks, Talib, for that question. We've got a quick question on the text for you, David, from Gregory in Ballarat. He says his local Woolies is only selling their own brand milk. Originally, they said it was supply, but it's not now. It's purposeful, I think, for their own profit. Can Gregory report them to the ACCC? They also intend to charge more because of the container deposit scheme. Is that an ACCC matter too?
Well, let's deal them as separate questions. In terms of the I only sell my own milk, there's no obligation on anyone to stock someone else's product if they choose not to. In terms of the container system, they actually pay more for the bottles. So, in a sense, what you can get by taking it to a recycling centre is built into the price when you pick it up from the supermarket. So I'm very sorry, no.
Katie is in Clunes. Katie, what's your question for David?
Hi, David. We purchased our house in Clunes 2 years ago, and when the tenants that lived here were here for 12 years and they left it in an absolute state, which we happily took on because we wanted to fix the place up.
Yes.
But I accidentally
does that mean that was reflected in the price you paid, or what?
Not reflected in the price we paid, but
you took it. You took it in the condition it was. Yes.
Yeah, we took it in the condition it was.
Yes.
But there were things stipulated that the sale got drawn, or the what do you call it?
Settlement contract. Yes.
Took longer to happen because of them taking so long. Anyway, I opened mail the other day thinking it was mine because it's 2 years down the track. It was actually a VCAT letter to the previous tenants that the landlord is taking them to VCAT for the bond and cleaning fee.
Yes.
But there was no cleaning done. There was no, as far as I know, the agent said there was not even a final inspection because the place was left in such a state.
Yes.
I'm just wondering, it just seems fraudulent for them to apply for that. I mean, absolutely the tenants shouldn't get the bond back. But then on us, it cost us thousands of dollars to clean up the mess that they left. In the end, we just gave up.
Your problem, Katie, is that you haven't seen the case that's been put to VCAT by the owner.
No, not the whole thing. I get that, but I'm just wondering, it just doesn't seem right to me, that's all.
So why, if you want to, you could go back, you could write back to VCAT and say, the address is wrong, they don't live here anymore. Mm-hmm. But in the event that they do respond to the application, can I suggest that you get them to contact me? I may have some information for them.
Yeah, okay, that's an idea.
Well,
and are we able to take them to VCAT for any costs incurred post-fact, or
Well,
just, we
you've
just have to
got
suck that up
you've
with the
got
settlement.
no claim against the tenant, and you've already resolved all of your issues with the owner.
Yeah, true. All right.
Sorry,
cool.
nowhere to
I
go.
just wanted to. All good. Thanks. For
Thanks,
your help.
Katie.
Bye.
Jenny is in Adelaide. Good morning, Jenny. Thanks for joining us across the border.
Thank you. Good morning. Query just with regard to marriage breakdown, so a lot of emotion in there, but also separated under the one roof is the state of what's going on. And do you need a date of separation prior to apply for divorce, or what is the sort of law around that, please?
Well, the date you've got, in order to get the divorce, you've got to establish that you've been separated for more than 12 months. It can be under the one roof. It's then up to you to establish to the satisfaction of the court when and how the separation started. So you don't have to say that on the 1st of January I moved into the other bedroom and I bought a new fridge, so he could have one and I've got the other. It might be simplest enough to say that in January these things happened, right? And these are our current living arrangements. So it's not, you don't have to be able to pick it down to a date. But and you may or may never get asked. There may be no contest from your soon-to-be former partner. But the process is you have to establish, if not a date, then a date range within which it occurred. So by the end of January, we were living separately apart. So in January, we did these things. By the end of January, our living arrangements were as detailed below. And if you've told other people, your siblings, mum and dad, then that becomes evidence of that you can use if you needed to. So if there's a contest, then you're able to come along and say, well, when the marriage came to an end, I went down and sat down with mum and dad and I told them X, Y and Z, and they're able to corroborate that.
Do we need to have that in writing, or unless it gets ugly?
Well, you need to know it's coming. You don't need to have it before you start. So, I can't imagine. I mean, the issue is living separately and apart is something that can be seen by other people. Living separately and apart under one roof is harder. So you normally need to go into more detail. So it's not I moved in with mum and dad. It's we made these changes to our living arrangements.
Okay, thank you.
Thank you.
I hope that helps, Jenny. Now, John is in Corryong. Good morning, John. You got a question about a car?
Yeah, good morning. David, I'm doing this to help a friend who's got some pretty severe mental health issues and they're homeless. One sort of feeds into the other, regrettably. They were driving their vehicle before Christmas. They scraped the front bumper bar of a 6-year-old car. Neither party were insured. The person driving the other car said it was a rental car. My friend has since received a letter from apparently a legal firm. There's no logo, no trade name, no nothing. So she was really dubious and she's scared of being ripped off. Anyway, I had a look at the email. They're claiming $6,400 for the cost of a scratch on the front bumper bar for a 5-year-old car, but then there's an assessment fee of $440 and legal fees of $770.
Wow.
Yeah, so I'm wondering about, there's no other quotes, there's no pictures of it. It just feels scammy, and this is when this happens to my friend, she just clams up.
Okay, John, couple of things.
Yep.
If it's a rental car, you often get a claim for the period in which the vehicle was not earning money. So if I owned a car rental business and you hit my car and it's off the road for 3 weeks, and there's an expectation that for 17 days I would have been renting it and receiving approximately X, then I've got a loss of use claim.
Yep, there's nothing in there about that, no details.
So
whatsoever.
ask for a copy of the assessment.
Okay. Would that incur more legal fees? Because it seems
I don't believe you're obliged to pay the legal fees anyway. There's been a couple of disciplinary cases at the Legal Services Board about lawyers who claim legal costs when there's no entitlement.
Yep.
So I could write you a letter that says my client has incurred expenses of $700,000 with me and I expect you to pay them as well. That's okay.
What I was fearful of.
But
Yep.
if it, on the other hand, is and you owe us a further $700 for legal fees, that's not
Yeah.
okay.
Indeed, $440 assessment fee. Is that worthy of being questioned?
Well, you don't know what the assessment says yet, John, so you don't know.
Yeah.
Look, you
Sure.
need to think about it from crash and bash days. What used to happen was that every time a car went to a repairer, the insurer would send out an assessor
Yes.
to make sure that they weren't being ripped off by the cost of repairs.
Indeed.
So it's normal for there to be an assessor.
Yes.
It's their way of proving that the fee was reasonable. But your starting point for a 5-year-old car is show me the quote on which the assessment was based. Did they get
preferably.
other things done at the same time?
Yeah, preferably quotes plural. All right, thank you, David.
Thank you. You'll only get one, but one should be enough.
Thanks to John there. Someone's just texted in saying, as I read the rules, there is no 10% deposit on plain milk containers. So that question was probably moot anyway. We've got time for a call. Andrea is in Foster. Good morning, Andrea. How are you?
Oh, good, thank you.
What's your question for David?
Yes, well, it is about actually a burial situation where I found out where my ancestors were buried, and it had been damaged, and the cemetery is doing an insurance thing on it, and that's all going through, but taking a very long time. And in the middle of all this, I sort of suggested I know who the people are that have the right of interment, and you know how they fit in, and just for interest's sake. And the people organising it all said yes, they'd get that person to contact me, and they've never contacted me over the last 2 years. It's taken a very long time to get this done, the insurance, and those people originally came forward to say who they were, and the person who was looking after all of that is now passed, and from the cemetery trust where it is. And I'm just a bit concerned because I have been there, and there are other graves there that have the same family name, and I would like to know if there's some recourse or to find out who this other person is and what are the actual procedures for rights of interment.
Here's what normally happens.
Yeah.
The right of interment. So if I had a right of interment, so I had prepaid my gravesite, my executor would own the right of interment after I died.
Right.
And that person's executor would own the right of interment after that person died.
Yes.
Now, on the other hand, it's possible to transfer a right of interment. And I've got one at the moment where I refuse to, I'm the executor, and I refuse to transfer the right of interment to the beneficiaries because they're I'll call them marginally dysfunctional, in the sense that I can't be sure that they will act as one, and the legislation, the Cemeteries Act, allows any one of them to act as if, in a sense, to deal with the right.
Right.
So I'm trying to make sure, I'm trying to keep the peace by not letting it go.
Yeah,
so you can look at, if you want to find out who owns what right of interment, you really start by looking at the paperwork, but the funeral.
Sorry, can I just ask a question? Am I entitled to ask to look at the paperwork? I have got an email from the person I'm dealing with, and she said, "Oh well, it'll stop the work on the grave." But I mean, it's on the gravesite, but it doesn't.
Well, it's 2 years. It doesn't really matter much anyway. No, Andrea, why don't you make a Freedom of Information Act application to find out who owns the right of interment for that site? And while you're at it, the other ones while you're there.
Yeah, I just thought it would be an easy thing to do, but obviously people don't always want to come forward, do they?
No, and not everybody wants to share information, Andrea. Somebody might not want Andrea Foster to know who they are.
Yeah. I know. And so how do I do that? Get this...
You write a letter to the manager of the Cemetery Trust. It's a Freedom of Information application. I want to know who holds the right of interment in respect to the following graves.
I hope that answers your question, Andrea. David, thank you as always for being here. You'll be back here same time next week.
But you won't be. So
I won't be, no.
Okay.
No.
We'll see you down the track.
We will. Thank you, David, for all your time.